All right, and after a little technical difficulty, we're back on the record in cause number 2020 DCV 3335. I'm sorry, Mr. Marks. If you would please continue the remainder of your argument.
Sure. Your Honor, as I've said, I think I've presented the court with more than a scintilla of evidence. And then it just becomes down to a question of fact for the jury. And if the court were to grant this partial summary judgment at this time, it certainly would potentially inject error in the court before we even get started. And so, like I said before, I don't know if you heard this, there are 3 other times when this court can make this decision. At the close of my evidence, the court can grant a directed verdict. At the close of the case, the court can grant a JNOV, and even after the verdict, the court can strike that JNOV after verdict, and then directed verdict after the close of the case. And so I just think that given the evidence that I've presented, I think that creates a question of fact, and I think it would be in the best interest of this court and for the record to let's see what the evidence shows at trial, the complete evidence. So for that reason, I would ask that the court deny their partial motion for summary judgment on gross negligence.
Okay, Mr. Chambliss, if you have a brief response.
I do have a very brief response, Your Honor. It's interesting, Mr. Marks would argue that let's see the complete evidence. The reason we filed a traditional and a no evidence motion for summary judgment was to see this evidence. If he had evidence from his expert about center stack airbags showing that Ford didn't care, then where is it? It's not in his response. There's no affidavit from any of his experts in the case. His argument goes back to a point I made earlier, where these liability and gross negligence get conflated. Mr. Marks' argument would have been proper if my motion had been for summary judgment that Ford on whether Ford was negligent in how they designed this vehicle, because all of his arguments were directed toward that according to Mr. Marks, Ford didn't have any of this testing and they didn't employ certain countermeasures. That all goes to the liability of whether Ford was or was not negligent in designing the vehicle and whether the vehicle was defective or not and cause these injuries. This is a different type of issue. It's a very specific issue, and it requires a heightened burden of pleading and of evidence, a clear and convincing evidence. I would encourage the court to read his evidence. It doesn't say quite what he says it says, and none of it overcomes what, I mean, he says Ford didn't care. If Ford didn't care, why was Ford part of a consortium to study occupant protection and far side impacts? A consortium where they share information with other engineers, and then from that employ 2 of the measures. That's as a matter of law, that's caring, and it's not caring, Your Honor. And I would also suggest to you that if you remember the photograph I showed you, Your Honor, of that B pillar and where Miss Jenkins' head unfortunately struck, that above that was a deployed side curtain airbag that Ford had put in there. Had Miss Jenkins' head been 10 inches higher, it would have made impact. It would have made contact with that. We might have had a different outcome here. But the point is, that's what Ford did. But when you get in crashes where you have 50, 60 mile an hour vehicles traveling and 40 some odd plus Delta Vs and significant crush of vehicles, you're going to have risk. You're going to have injuries. And that's why Ford employed measures like they did, such as a pre-tensioner. So Ford did these things. That is the caring. And just to say they don't care, all those arguments go to the liability portion of this. And I would submit, as far as injecting error into this case, Your Honor, that's why we have summary judgments. If the evidence is there, you bring it forward in no evidence motion. It's not there, I would submit. And Your Honor would not be committing error by granting this motion. In fact, it would be sort of streamlining a lot of this case, including voir dire, including pretrial motions. So I would encourage the court to read the evidence. Again, this is gross negligence. This is not the merits of the case. So thank you, Your Honor.
Thank you. I am going to follow Mr. Chambliss's invitation and go over a little more thoroughly both the original motion filed, kind of narrowed down now, and response from plaintiff. I see that we have a final civil pretrial on October 5th. I'm sure you all have a ruling on the summary judgment prior to that date. So bear with me. I don't know if you all, as a matter of routine, submit proposed orders, but both of you all, if you all have them, go ahead and send them over if you could in Word format so I can look at them. So that's on the partial summary. Anything with respect to, I guess, our status conference today, other than outside of the summary judgment? If not, then I will see you on October 5th.
Your Honor, this is Carlos Rincon. I had previously filed with the court early August a notice of conflict of setting. I am, as I understand it, set priority in a matter in Bexar County. It's listed out, Castillo Cole versus True Light Glass. It's in cause number 2017 CI 19227. It's a matter that has been almost called to court and reset for various reasons. We've mediated the case, I believe, twice, and it looks to be a matter that is going to go to trial. And as I've told my client and my colleagues here with Mr. Peterson and Mr. Chandler's firm, and I've shared this with Greg Marks as well, it can't be at two places at once. And so I follow the local rules on how to address that. And so on that, I'm just going to need some guidance from the court as to how they handle it. It's peculiar because I think this is the first time in 34 years I've ever had a conflict with a trial setting in El Paso with a case pending outside of El Paso. And I don't know how that works, but you know, in El Paso, typically the courts have a methodology, which case is filed earlier, set earlier, that kind of thing. And I did want to alert the court to that conflict. So we can address everything else on when we reconvene on the status conference.
So I have a notation of that for the final status conference today to discuss trial scheduling and whatnot. So thank you, Mr. Rincon, for bringing that up. I don't know that I remembered that. You know, in terms of scheduling the trial outside of that November 4th setting, did you all have any thoughts? Have you all discussed any potential backup dates? I have a notation also that you all are anticipating this trial lasting 2 weeks. Oh my, maybe there's something wrong with the computer or the internet because nothing is quite responding. But in terms of a backup date, yeah, people are getting kicked out. Something's going on. Okay. In terms of a potential backup date, I know we especially set another case today. I kind of would be inclined to give you that as a backup date as well, because that other case was still has the potential to resolve in mediation, and that the date on that is January 20th. But if that doesn't work, then what I would ask is for you all to confer and come back on October 5th. Is that our next date, Golly? Now I'm getting on.
Yes, it is.
Okay. And give me some potential, if you could give them to me ahead of time so I could look at them and check our calendar. It is tricky. The first 3-4 months of 2023 are very tricky. What I could tell you is it wouldn't be 2020.
Your Honor, I haven't conferred with Mr. Peterson, who is the lead counsel on the product liability issues. I would be available on that alternate date in January. I don't know what his schedule looks like, but if not, we can confer with counsel.
Okay.
Yeah, Your Honor, this is Brad Peterson. I currently do have a conflict with that date. I'm happy to get with counsel and see if we can identify some alternative dates. as you noted, this is a 2-week trial setting, so it's going to be significant. And as you probably gathered from this hearing, it's going to require it's going to be very expert intensive, and people traveling outside of the state of Texas from all over the country, and we're going to have to make travel arrangements and all of those sorts of things. So the sooner that we can decide whether we're going to try this in November or not, the better, I think, for both parties and their planning purposes and saving litigation expenses overall and those sorts of things. I think that that would be good. And I did note the court mentioning that the November 4 trial setting was a big one, that you'd set a number of cases for that. And so we understand that. And I think it would just behoove the parties to know whether we think our trial is realistic on that date, or whether we think it's going to be moved so that we can start making some adjustments, particularly with regard to the great expert expense in the case.
Yeah.
Your Honor, I'm sorry.
Go ahead, Mr. Parks.
Thank you, Your Honor. I would just say that, I understand Mr. Rincon's conflict, and if he has that conflict, there's really nothing we can do about it. My client would like to get to court as soon as possible. And so if because of Mr. Rincon's conflict, the 4th is ruled out, or because of the court's calendar, the 4th is ruled out, I would ask that we get a special setting. Now, what date that is obviously up to the court, and January 20th is fine with us, but I would like to get it as soon as possible. That, I guess, is what I'm trying to say.
Yeah, Judge, and we'll work with Mr. Marks, but as indicated, if there's any way you could give us firm assessment as to whether or not we're going to go to trial in November, because Mr. Peterson's we already know is not available on the 20th of January 2023. So it will give us a chance to confer on dates and then try to lock in a special setting.
So the number one red flag that I'm seeing now, and I hate to kind of speak on these things because lo and behold, I say it, there's nothing really definitive, is that I do have a murder case set on the 4th. Person is in custody. But even with that said, I'd like, what that would tell me is that at the end of the day, that's going to supersede kind of the order it's going to take precedence on the order of November 4th. But lo and behold, even these inmate murder cases get put. And so I'm looking at it. I'm looking at the docket for November 4th. We also have another case. Yeah, well, in light of Mr. Rincon's conflict, I don't know how November 4th works.
Your Honor, would it be helpful if we were to get with your court coordinator and identify some dates where a special setting would work, and then try to compare and match calendars, and we'll get back to the court?
That would be useful. Like I said, if you have agreed on dates that you can present to us, what I can tell you though, and I'm fairly comfortable saying this, is we're at least 4 months into 2023 before I can block out that kind of time on a special setting, because I know we've been filling 2023 with special settings already. With that said, and I don't even want to throw this out there, so I'm not, so we'll just leave it at that. So how about you all come up with about 4 dates in 2023, and we'll do the same on our end. If you will email Ms. Hernandez with those, and that way she and I can sit down and look at basically what will be the week surrounding whatever dates we have, that if the court is able to schedule you, what the other weeks look like. We'll go from there. But I mean, we're coming back on the 5th, so that's not too far down the road. At this point, yeah, I think November 4th is not workable.
Okay.
If you need, I would ask that you file something with respect. I didn't look closely at the notice.
We did file notice of conflict, and so what I'll do is I'll notify the Bexar County District Clerk that this conflict has relieved itself. So with that said, Judge, we're we're free to release the date of November 4th with our experts, and we'll contact immediately with Mr. Marks and get dates, a range of dates for a special setting. It looks like beginning in April, moving forward in 2023, so that we can lock in a certain trial date.
Mr. Peterson, was Mr. Peterson the only one that had an issue with the January 20th date?
I believe so, Your Honor. I mean,
Oh,
but to be fair, Mr. Peterson is the lead counsel. So
Yeah.
forward.
Okay, no, I want to make sure, I didn't know if we had fully, I know he spoke and I don't know that I asked anyone else. Let me go back to.
Your Honor, if I could say something of what Mr. Rincon said,
Uh-huh.
which I appreciate what he's saying, but given the potential delay, I would like to hold the November 4th in case Mr. Rincon's San Antonio case settles. I'd like to hold that date and then maybe have a special setting date as a backup in case we don't get reached, would be my preference.
Let me throw something out there, and since you're all here, what about January 6th?
I believe that date's fine with me, Your Honor.
Your Honor, I apologize. I'm checking right now. It may be that I can make that work, but I need to just confirm something that's not apparent on my calendar right now, because I think that next week, which would put us at the week of the 16th ending on the 20th. I think that is going to be free, and I think I could make that work. I just need to confirm it. And I'm happy to get right back to the court with that immediately in council, because that might be possible.
Okay, so I'm going to kind of go along with what Mr. Mark says. We're going to leave the November 4th setting for now, not specially set. And I'm thinking we're going to specially set for the 6th, because that will give me enough room. We were kind of light coming right back after the new year, and that might work. So
Yeah.
that's what I'm okay, so we'll wait for you, Mr. Peterson.
Thanks, and we'll obviously check with our experts too to make sure that they are out of the country or doing something else, and probably both sides need to do that.
If you can all double check all of those things by the 5th of October, we may have our date.
Great.
Perfect.
Okay, thank you, everyone. Anything else? Mr. Bayman, did you have something?
Yes, Your Honor. Thank you. The court had appointed Ms. Jessica Mendez as the guardian ad litem because the settlement in this case involves one minor. And I know that Ms. Mendez is working to contact the minor's family and get all of the records in place. So we do have a hearing tentatively set, I think, for October 12th, barring anything going sideways with Ms. Mendez's investigation. So knowing that, would the court require the presence of myself as counsel for defendants HMV and Mr. Martin at the October 5th status conference?
No, not really. Good point, Mr. Bayman. Unless you want to be here, I think we're good to go. We have you scheduled the following week.
Yes, Your Honor, that's correct.
All right.
All right,
Anything
thank you so much.
Take care. Anything else? Not? We'll see you all on the 5th.
All right. Thank you, Your Honor.
Thank you,
Take
Your
care,
Honor.
gentlemen. Thank you for your time. All right.
Bye.
So we still have a lot to go here. Let's get the expunction. All right.
Okay, Judge, in cause number 2022 DCV 1215, the expansion for a Mr. Nicolas Olag Short. Announcement of council, please.
Jeff Frog on behalf of Mr. Schwartz, Your Honor. We are not ready and we'll explain why in a second.
I'm sorry?
We are not ready and we'll explain why in a second.
Okay,
And good morning, Your Honor. Jed Unterrecker, Assistant County Attorney, on behalf of various county respondents.
okay. Mr. Rago, go ahead.
Yes, Judge. I have been in contact with Mr. Jones, and I think and I apologize if I butcher your name, Unterrecker.
Mhm.
You nailed it. That was excellent.
Okay. I've been in contact with Mr. Jones, and we've actually received a letter from Curtis Cox where it will not be contested, but there was a clerical error in it. We had to send it back to him so we could get a new signature. And once that comes in, there's going to be an amended response by the county. And I believe we'll have an agreed judgment to you, Judge, if that's correct too.
Okay, it's reset for 30 days.
Okay.
Yeah, and Your Honor, that's our position too.
Okay, thank you, Mr. Unterrecker. Appreciate your patience. Thank you. You all are
No, thank
excused.
you.
Thank you, Your Honor.
Take care.
Thank
Bye-bye.
you.
Who's next?
On the last page, Judge, in cause number 2020-0D01167, State of Texas versus Eric Leal. Announcement of council, please.
The state's ready, Your Honor. Sorry, just trying to start my camera.
Good morning, Your Honor. Denise Butterworth on behalf of Mr. Leal.
Okay, hold on one second. All right, probation status hearing. Actually, it's not on my paper docket. So let me see, is Mr. Leal in custody? No, he is not. Is he here?
No, Judge.
Is this not one where they check in on Mondays? Did I mess up here?
Did he check in, Mr. Marufo?
No, Judge, he did not check in.
That's gonna be on me though. That's gonna be my fault.
Let me get into Odyssey really quick.
I think I am racking my brain, but I think this was a kid that we were just gonna check in and see how he was doing to determine if we were gonna dismiss the motion to revoke. I think that's what this one is.
A ver, Carlo, will you, I'm trying to get back to my criminal stuff, including your case summaries. Can you inform, por favor?
Yes, Your Honor.
Ugh.
I'm sorry, everything's like stuck on.
Yes, the computer, everything is very, very slow.
Okay, so yes, I believe what Ms. Butterworth is stating is correct, Your Honor. The last time we were here, Mr. Leal was bonded out back in June. He was let out to continue on probation.
Okay.
In July, there was, I believe, another hearing where they were probation actually covered that hearing, the probation officer. And it was just basically going over everything that he has pending, but he was also going to have EHN appointments upcoming.
Ms. Pineda, I see the report now. I'm sorry to interrupt, but I know we're kind of really behind this morning. I agree. I just read the case summary. It looks like he's on track. Ms. Butterworth, it does give me a little bit of concern. I don't know if we stated it the last time that he was here, maybe he wasn't required to be here. When we have hearings, how many hearings do we have? We have any more scheduled? No. And he didn't get extended, right, Carla? So he terms at the end of the year?
Yes, Your Honor.
Okay, so I don't see anything negative on this report. So unless I hear from probation, I'm not going to need to see him back. Ms. Pineda, if there becomes an issue with, he's MIA, I don't think he would be, but if there is, I'll rely on probation to let me know. Okay?
Okay, Your Honor.
All righty. Thank you very much. Thank you, Ms. Butterworth.
Thank you, Judge. So there will be no more hearings on this kid and we wait. If nothing else happens, he terms.
Correct.
Okay, thank you all. May I be excused?
You may. Thank you very much.
Thank
Who's
you.
next?
cause number 2022-0D00564 and 2019-0D03583, State of Texas versus Joseph Rodriguez. Announcement of council, please.
Roa
Samantha
King,
Rowe.
from State of Texas. Good morning.
And Myrna Pages from Mr. Rodriguez. Good morning, Judge, and good morning, Roa.
Good morning.
All right. Okay, so we had the probation case, but he's got a murder. Murder is set for January 27th. He's in custody. I'm not quite sure what we're doing here. Miss Carla, anything? How are we doing on our new case? Are we good to go for January?
Judge, we are, let me look at the email. We still are missing some testing on a GSR kit that was taken from decedent's hands. It was submitted to DPS, but it was not tested. So I just want to make sure that that is underway because we will need that.
If I may, Your Honor, Ms. Pages, are you referring to the one that we sent out, the WC-01, the third one that wasn't sent out?
Correct, WC-01.
I have sent an email to see on a status for that. I haven't heard
Okay.
anything just yet.
Okay, great.
Okay, I just, there, in terms of the probation recommendation and the probation status hearing, I just want it notated that they want to continue him on community supervision. Okay.
Judge, actually, I'm not surprised that that is the case, and I guess once the court hears the facts of this case, you'll see why.
Okay, understood. All right, if there's nothing further, ladies, thank you very much.
Thank you, Judge.
We have future settings, right? Meaning the probation case. I know that the murder cases, yeah, we have our settings all squared away. Thank you, ladies.
Okay.
All right, who's next?
Your Honor, just if I may add, just to make a notation on Mr. Rodriguez, the murder charge was allegedly the offense occurred prior to him being placed on probation.
Correct.
Oh,
There were
okay,
11 days in between, I believe, Your Honor, between
Okay.
each offenses.
strange. All righty. Thank you very much. Thank you, Carla. Who's next?
May I be excused, Your Honor?
Yes, thank you, Ms. King.
Thank you, Judge.
Judge, Mr. Parra's office is still trying to track him down so he can log in for his client, Mr. Nunez. Mr. Nunez is in the waiting.
Okay, let me look at the case summary very quickly. Okay. All righty, let's go ahead and get off of YouTube. Is this our last case?
Yes, Judge.
Okay,